Hello friends, today we will start discussion from section 17. Section 17 is definition of admission. An admission is a statement, oral or documentary or contained in any electronic form which suggests any inference as to any fact in issue or relevant fact, and which is made by any of the persons and under the circumstances hereinafter mentioned. This is the definition of admission. I will discuss the definition of admission at the end of this video. Before that, I want to discuss some features of admission. First, number one, to constitute admission, the following characteristics are to be present as per the definition. What are that? Number one, it may be oral or documentary or in any electronic form. Number two, it is a statement to suggest any inference as to any fact in issue or relevant fact. Number three, it may be made by any person prescribed under the Act. We will get the details of the persons who can make admission in the sections 18, 19, 20, etc. And number four, it must be made under the circumstances prescribed under the Act. So these are the basic characteristics which are required to treat a particular statement as admission. Now, what are the principles of admission? There are four principles for admission. What are that? Number one, an admission can only be examined as a whole and cannot be divided into parts. If a particular statement is an admission, we have to take the entire statement. We cannot break and take a part of this statement. The entire statement has to be considered, not a particular portion. Admission can only be read in its entirety, and no statement can be taken out of context to form an admission of a fact. So, if a statement is an admission, the statement to be considered in its whole, the entire statement, not any part of that statement. So we cannot use any part of your statement as admission. We have to consider your entire statement. And if after considering the entire statement, if we find that there is some admission, then the entire statement will be considered as admission. Principle number two, an admission binds the maker to the fact of the case. However, not in so far it relates to the question of law. Admissibility of plea of guilt can be determined only if the plea is recorded in the words used by the accused. What is that? An admission binds the maker. I am making the admission. My admission binds me to the facts of the case. Binding on which? Upon the facts of the case. However, not in so far it relates to the question of law. Admissibility of plea of guilt can be determined if any accused pleads guilty. Then how it is to be determined and considered? Only if the plea is recorded in the words used by the accused. The exact words used by the accused should be recorded, and based on that, plead guilty can be considered. Principle number 3. For an admission to have a substantive evidence effect, it should be voluntary in nature. Any admission made in ignorance of rights or under duress cannot be considered as admission. Any statement made under force, under influence, under any coercion, under duress cannot be treated as admission. It should be voluntary. The maker should make that admission, that statement out of his own will, not under any one's influence, any coercion, any threat or anything. And number 4, admissions are limited to being only prima facie proof and do not carry a conclusive value. Admissions are only prima facie proof, not conclusive value. Admissions which are clear in the words of the accused and true are best proof of facts submitted. Very important thing. Admissions are limited to being only prima facie proof and do not carry a conclusive value. Admissions which are clear in the words of the accused and true are the best proof of facts submitted. These can be treated as the best proof of the facts submitted. Now, there are 2 types of admissions: judicial admission and extrajudicial admission. What is judicial admission? Admissions that are made by a party during the proceedings in the case are referred to as judicial admissions. That means judicial admissions can be made only before the court. Note the word proceedings. Admissions that are made by a party during the proceedings in the case are referred to as judicial admissions. So judicial admissions can be made only in connection with the proceeding and during the proceeding. What is extrajudicial admission? Admissions that are informal in nature and do not appear on the records of the case are referred to as extrajudicial. Admissions which are informal in nature. My friend Ram murdered Mr. X, and after the murder came to me and admitted to me that he murdered Mr. X. This is informal in nature and do not appear on the records of the case. This is extrajudicial admission, not judicial admission. In this regard, I want to mention one very important case, Ajodhya Prasad versus Bhavani Shankar, AIR 1957, Allahabad 1 FB. The Honorable Court held that unlike judicial admission which are binding upon the parties, so judicial admissions are binding upon the parties. I cannot move out from my judicial admission. Unlike judicial admission which are binding upon the parties, extrajudicial admissions are only partly binding. The exception to this principle is found in cases where they operate as or have the effect of estoppel. When it is partly binding? Only when they operate as estoppel. What is estoppel? Estoppel means once I said something, I said that yes, this land belongs to Mr. Ram and I am not the owner of this land. I am stopped from claiming the ownership of that particular land. I am stopped from claiming the ownership of that particular land. So, judicial admissions are binding upon the parties. Extrajudicial admissions are only partly binding. The exception to this principle is found in cases where they operate as or have the effect of estoppel. Only in case of estoppel they are binding, otherwise not. Now I am coming back to the definition of admission. An admission is a statement. Requirement number 1 is that admission should be a statement. What kind of statement? Oral or documentary or contained in electronic form. These 4 words or contained in electronic form was added in the Evidence Act later in the year 2000. So an admission is a statement, oral or documentary or contained in electronic form, which suggests any inference as to any fact in issue or relevant fact, and which is made by any of the persons under the circumstances hereinafter mentioned. This definition of admission is very much important, and the 4 slides which I shared with you, these are very much important in my opinion. Along with the section, these 4 things should be studied. That's why I shared these 4 slides with you. You may note down it or take screenshot of the slides. In my next episode, I will start from section 18. Till then, have a nice day and stay safe. Thank you very much.